Ladies and gentlemen, we have to evacuate the building at this time, so we'll be in recess until we discover what's going on.
All right, an unexpected twist in an already just dramatic trial, we'll say, as we refer to the trial of the century in South Carolina at the Murdaugh murders trial today. Welcoming in our expert analyst, trial attorney Carl B. Grant. Carl, as we listen, we did hear the judge use the word evacuate, so he did not dismiss the jury as he typically does. We have not received any reports that the bomb threat was explained to the jury. How could this unexpected development complicate this trial?
Well, when you hear something like bomb threat, the interest in the wheels of justice must come to a halt. It then becomes a police matter, of course. The first thing on the judge's mind at that point is the safety of the courtroom and the courtroom personnel. So you get the police authorities in as they did, and then of course they do the investigation to determine if in fact there is a bomb, where is it located. If not, then the wheels of justice pick back up. Now to that being said, if there was a bomb threat and it was confirmed and it was communicated to the jurors that there was a bomb threat, the question becomes, what impact would that have upon the jurors' ability to continue to serve and to do so fairly, neutrally, and impartially?
And then what about a mistrial? Some people are wondering about the legal standard for the judge to declare a mistrial, especially considering the bomb threat today, in the middle of testimony.
Right. The last thing the prosecution would want, of course, in this case is a mistrial. Why? Because so many government resources have been used to bring this case to trial. Think about that long jury list that they had to go through, 900 potential jurors. Surprisingly, it only took about 2.5 days to pick the jury, but they have expended a lot of money at this point to get this case to trial. So that's the last thing the prosecution wants. The defense, on the other hand, probably they don't want a mistrial either. However, there are reasons why the defense would not want a mistrial. Number one, the defendant is being tried in his own backyard, a backyard that involves 100 years of influence by his family name. So that's maybe one reason why they would not want a mistrial. The prosecution, on the other hand, does not want the mistrial because of what I already said, the money and effort that has already been spent.
And Carl, there was a lot of testimony. In addition to these unexpected developments, they focused a lot on the gunshot residue. And I think the defense did a pretty sound job in trying to explain where that gunshot residue could have come from, how long it could have been there, that it could have been there for years if no one took the time to clean it. How compelling was that? Finally, something that may have gone their way in this case.
That's good. That's a good argument. Gunshot residue is pretty much similar to DNA. It might be there, but you can't say when it got there or how it got there. For instance, we know that DNA can actually be on a mummy for 1,000 years or more. So that's the question. And I thought that was a good line of cross-examination. How do you establish how and when this gunshot residue got there, and of course, who put it there and under what circumstances? So I think that's a good line of questioning. So I thought they made some points on that.
There's also testimony happening from a computer specialist who was looking at when and where Alex Murdaugh parked his car, and how long he stayed at a destination. But in that same testimony, it was also explained that sometimes the computer in the car stops recording at that point. So is that really helping prosecution at this time, or is that something the defense can take a hold of because it's inconsistencies in that timeline? As
with all other inconsistencies, is going to be the value that the jury puts on the evidence and whether or not the prosecution can prove its case beyond a reasonable doubt. Keep in mind, again, they have the burden of proof. Not just the burden of proof, but the burden of persuasion. They must persuade the jury that it is what they claim it to be, and to do so beyond a reasonable doubt. So yes, that could be problematic. Anything that's not strong enough to prove the case beyond a reasonable doubt can be deemed to be faulty.
How do you expect conversations to go once the jury starts deliberations as they talk about these financial crimes? Because the paralegal who testified today and the other testimony that we've already heard is just so compelling about I have no idea how he was able to do it for so long. I mean, it raises questions about the checks and balances at the law firm where this was able to go unnoticed for so long. But I don't really think there's any doubt, Carl, about the financial misdeeds here. But the question is, how will the jury factor that into their decision?
It depends on whether they follow the judge's curative instruction, that this is the only way that you can use this evidence for purposes of motive. However, if they go back and start having general conversation and seemingly forgot about that instruction and say, wait a minute, based upon all of this financial crimes information, we think this guy is a chronic liar. and then they start imputing that information to character. We wouldn't know, of course, we won't be in the jury room.
Exactly.
We can only hope that the jury is going to follow the judge's instructions. Most times they do, sometimes they don't. So it depends on how they value that evidence and the value that they give it in determining how it's going to apply to the elements of the crime and the proof that the prosecution has to meet.
At this point, what are the challenges for both the defense and prosecution? It's a lot of information, trying to break it down to the jury. What do they need to do with yet another piece with the financial evidence crimes to make sure that the jury is getting both of their points?
Sure. The prosecution, again, having the burden of proof, they have to really establish that the financial crimes rose to the level that it could really be a motive to have committed the murders as they promised in the opening statement. They must establish that Mr. Murdaugh was in such a, I guess you'd say, a kettle with stress upon him where he's about to explode, and all of a sudden he decided to commit these very horrible crimes by killing his family. On the other hand, the defense, they just have to pretty much stick to what they're doing now. The argument is going to be this is a ridiculous line of theory as far as prosecuting, and argue that the prosecution did not prove his case. So that's what it is, and that's how it's going to be. But the jury is the ultimate decision maker here. And when it comes to mistrial, once again, mistrial is normally declared in the interest of justice. That's what the judge has to do, preserve the interest of justice. If the judge ever deems that the interest of justice cannot be preserved, then the judge must declare mistrial.
Thank you so much for helping us to break it down so that we understand it and our viewers as well. Court will resume tomorrow at 9:30, and of course our Greg Adeline and Nick Neville are there